first motion we need to discuss prior to anything else is the motion for a new trial. So that would really have impact on the decision.
Actually, Judge, may I address the court?
Sure.
I think there's actually two other things we need to take up before that.
Okay.
First of all, Mr. Ward has indicated to me that he's indicated that sometimes he didn't want to do this by video conference. He preferred to be in person. So I'd ask the court to inquire directly if he is wanting to do this in person or if he's waiving that and wants to do this by Zoom video conference.
I'd be glad to do that. Mr. Ward, I'm sure you heard Mr. Simmons' statement. We are doing this by video conference because of the COVID-19 crisis. Are you willing to consent to that particular procedure, or is it your desire to do it in person?
Well, I'd rather do it in person since you guys have been lying in my case. I pointed that out on 219. You and the prosecutor had misconduct in my case right on the script. So guess what? Somebody else needs to contact the KBI or the Attorney General's office. You guys are not allowed to lie. That is perjury, and I want to file charges. That's all I have to say.
Okay, so I
Your Honor?
Mr. Ward,
I'm sorry.
I think Mr. Ward just left. He's went off screen.
Well, I'm still here, but I don't want to be. You guys can break the law and keep me here, but I can't. I can't do nothing about it. You guys can break the fucking law, Your Honor. You lied. On that stand, you lied. Ms. Breaker lied. Tell me you lied. Yes or no? Did you prove yourself? Yes or no?
Mr. Ward, I want to
Yes or no? So why do you guys keep me hostage right here in the fucking jail? You guys are about to break the law to keep me here. That was before the trial. Now, did you lie or not? Yes or no, Your Honor? Yes or no, Your Honor? Yes or no?
I'm going to put you on mute so I can say something. You can still hear me. Based upon Mr. Ward's presentation today, I don't think it's possible that we can do a Zoom video conference and give proper consideration to any issue the court might have to decide. I want to have to bring Mr. Ward over. At this point, I think I can safely do that after next week. The courthouse opens next week. The court will not open for regular business next week. But it's my understanding that the Supreme Court, which was just issued last night or this morning sometime, allows for appearances for less than 10 people in a courtroom as long as we can have proper social distancing. We can do that in our courtroom. 6, 7, 8 here with us, and of course there'd be jailer, that'd be 9, 2, and then the victim has the right to observe, but I think we can do a video thing for that. So this looks like this is something we can do. So I'm going to look at the week after next to have an in-person hearing on all the motions, because that will be, looks like Mr. Ward just left. So we will, and he won't have the opportunity to be able to leave, because we'll have jailers in the courtroom to make sure he stays through the proceedings unless he becomes disrupted.
Your Honor, I did have one other question that I hoped we could address today, but maybe we can't since Mr. Ward is gone. I was hoping that you could address the motion to withdraw so that if you granted it, he could have new counsel by the time we had our next hearing. But probably,
is there anything in that motion to withdraw that was really in addition to the complaints that existed earlier in this case?
Yes, Your Honor. 2 items. Our relationship has deteriorated. Our communication is, we're very adversarial to each other at this point, and he needs more in the way of counsel for that. The other item, which is more of an issue, is after reading the state's response to the motion for new trial, I'm fairly certain that I'm going to be a witness. So I can't represent him and be a witness at the same time. It goes to whether or not he waived by not objecting at trial.
Objecting to what?
Well, as the court's read the motion for the new trial, the court knows that it's based on the fact that he was wearing the bracelet during trial. And reading State v. Hall, the first obstacle that has to be overcome is whether or not the defendant waived his objection to appearing in jail clothing by not objecting at the time of trial. And I would be a witness to that because we didn't object, so then the question would be why.
I guess, trying to determine how I want to address that issue. I know, Mr. Simmons, that you asked for permission to give juror telephone numbers. Did you talk to any jurors?
I did not talk to them yet, Judge, because it came, once we had this conversation about the new trial, I thought I stopped working on the case to wait to see whether the court wanted me to continue as his counsel or not.
So the issue that, I mean, the only issue that you would testify to, as I understand it, would be why you didn't object. Is that what, I mean...
That's correct.
Were you aware that there was a bracelet on? I mean, I didn't notice when I tried the case, but were you aware that he had a bracelet?
I saw that he had the bracelet on his arm one day, yes. It did not occur to me to object, and he didn't ask. But I suspect that's what's going to come up in terms of evidence.
Spraker, you have any comments on that issue?
Judge, I have discussed this with Mr. Simmons, and after having read the case law, the state's position is going to be that he waived that by not objecting at trial. I would agree that Mr. Simmons could possibly be a witness if he did discuss that with Mr. Ward at trial, because that could go to the reason why, or if he was prejudiced. I can see that.
What would counsel think? What would counsel think about appointing counsel to make that particular argument, leaving Mr. Simmons in the case to deal with all the other issues that might arise?
Deal with the motion to withdraw, the motion for new trial, Your Honor?
Yeah, have somebody else present that, because it's not a jury issue, it's a court decision. And then the problem I have with appointing new counsel in this case is that, we're not going to start over. I mean, the counsel gets the case where it is. The problem is Mr. Simmons has a wealth of knowledge about the case that has nothing to do with the fact that there was an objection made or not made. That's a very small, minute issue. It certainly goes to effective assistance counsel, but only on that issue, nothing else. And so the court would make a ruling on whether the defendant had effective assistance counsel at the trial or not, which basically requires you to testify about one issue, which and everything else we don't really need the counsel for. I'm just trying to figure out how to deal with this so that we can move forward in this case without keeping Mr. Ward in jail forever, trying to re-educate lawyers.
If that's the order of the court, that's what we'll do.
What was it, June 15th? What time? I got the whole day available on June 15th. Are counsel available?
I am available, Your Honor.
I'm available also, I believe. I'm available all morning. I have some stuff in the afternoon, but if I need to get it covered, I can get it covered.
We'll set this for June 15th at 9, so we'll continue it over for arguing on motions and sensing if appropriate. I'm going to just do a little thinking about this withdrawal motion and how it can be presented. I'll let you know in a day or two. Anything else, council?
No, Your
Okay,
Honor.
we'll be in recess. Thank you very much.
I wonder why that motherfucker quit working.